Mr. LiBassi, you may proceed.
Thank you, Your Honor. Good morning, Your Honors. May it please the Court, my name is Douglas LiBassi, and I'm the appellant in this matter. I am before you today seeking a review of the single justice's entry of an order without findings of disbarment. Disbarment that, combined with my voluntary suspension 5 years ago, would result in a sanction exceeding 12 years. Today I'm asking that this Court determine three things. One being the appropriate sanction, two, whether the sanction should be mitigated, and three, whether the resulting ultimate sanction should be applied retroactively in light of the suspension. Before addressing my main arguments, I would like to inform the Court that I am not here today seeking a review of the findings of fact. I am aware of this Court's position that findings of fact are best left to the hearing committee. I acknowledge to this Court, as I did to Bar Counsel at the start of the investigation in 2001, that I misused client funds. Although my misuse was unintentional and caused in part by mitigating circumstances, the fact remains that I did misuse client funds, and I accept responsibility for doing so. When Bar Counsel first contacted me in October of 2001, I complied with her request for information regarding the Morgan monies. In my gathering of documents and records for Bar Counsel, it became clear to me that there was a shortfall of funds. At that point, I called Bar Counsel and told her that I was aware of it, that I realized that I had misused funds. And I told her I had no interest in belaboring the investigation, and I was willing to admit to that. Bar Counsel thanked me for my willingness to cooperate and advised me to get counsel, and within a matter of days requested my assent to a temporary suspension. Now, the question I've asked myself over the last 5 years is, why did I assent to the temporary suspension? It's come back now where I've been able to practice for 5 years. The existing sanction pursuant to the single justice removes my license for 12 and a half years. There's a very good chance if I had not assented to the temporary suspension that I wouldn't be in this position today. But I did so because I believed that there was no sense in belaboring the investigation. I wanted to cooperate. I was also led to believe that the investigation would take 3 to 6 months, and then the sanction would be imposed.
How were you led to believe that?
By two things, Your Honor. One, by my conversation with Bar Counsel. We had a lengthy conversation in which we discussed the matter. I disclosed that I had misused funds, and I asked her how long she thought the investigation would take, and I asked her how long of a sanction did she think would be imposed in light of the circumstances. She said that she didn't want to get into how long the sanction would be, the ultimate sanction, but the investigation would take 3 to 6 months. When she advised me to get counsel, I told her I knew I couldn't afford it. She advised me that Office of Bar Counsel could refer me to an attorney, which they did, and he told me the same thing after speaking with Bar Counsel. It turns out later that I found he had never represented anyone before the Office of Bar Counsel, that he was friends with many members of the Bar Council, and I suppose that's why they recommended him. But even in his handwritten notes that were turned over when I terminated his services, there are notes from the conversation, 3 to 6 months before the investigation will be finished. It then took Bar Counsel 18 months to file the petition for discipline. And by the time the hearings were actually scheduled in January of 2004, I had already been under suspension for over 2 years. The hearing committee then took another 1.5 years to render its decision. By the time the board issued its recommendation and the matter reached the single justice, it was June 2006, approximately 4.5 years that I had been not been able to practice. Now, the sanction recommended by the board was disbarment retroactive. The hearing committee also recommended disbarment. They made no statement whether it should be retroactive or prospective. However, I would like to make clear to this court that in both cases, the recommendation of disbarment was specifically predicated on the lack of restitution. Restitution has been made, and restitution was made in June 2006 pursuant to an ongoing Suffolk Superior Court case. In 2002, when I realized there was a shortfall of funds, I refinanced my home immediately and put the $53,000 in escrow with my attorney. It has remained segregated all throughout the proceedings. And it was my belief that I was following the ethics opinion of Bar Counsel in an article entitled "At What Cost Payment," where they said, if you're holding funds for a client and there's a dispute, representation is terminated, take the funds, segregate them, and make every effort to resolve the matter with the client. From 2002 until 2006, I or my lawyer contacted the client, repeatedly requested. We had meetings with attorneys. We tried everything. I offered to give him the money for his attorney to hold an escrow. He refused. Finally, the reason became clear. He filed suit and demanded twice the amount of the claim dispute. He wanted $120,000 and wouldn't settle for less. So I'm holding the money in escrow for 4.5, 5 years. Finally, the matter gets processed coincidentally at the same time that the Superior Court proceeding is going on the single justice and before the single justice. The point being that all the money was repaid in June 2006, over and above, almost $4,000 over and above the amount in dispute. The other, I don't want to run out of time here, the issue of mitigation. At the time that I misused funds, I was having serious difficulty. I was seeing a psychiatrist. I was also seeing a therapist. I was being treated for diagnosed post-traumatic stress disorder. I was on psychotropic medication, and I was severely abusing alcohol to the point where I committed myself on 2 occasions to voluntary rehab for a total of 42 days. I was going to LCL. And this was before the problem came to light with Bar Counsel. Unfortunately, at the hearing, my attorney filed a disclosure, the mitigation expert disclosure, 1 week late, and the hearing committee disallowed my expert witness. As a result of that, even though the hearing committee said specifically in their report that an expert would have been helpful on the issue of causation, there's no evidence to support it. They also said that they couldn't read the hundreds of pages of medical records which were provided by my treatment providers. And Bar Counsel has now said that because of that, I've been uncooperative. I'd like to say, Your Honor, that the delay it's been devastating to me. Loss of income, loss of reputation. Bar Counsel acknowledged, I filed a motion to dismiss with the single justice, which was summarily denied. I filed that because I felt the proceedings were going on too long. In her opposition, she acknowledged that the harm to me has been great. This court has recognized the harm to suspended attorneys in the Ellis matter, and also in the Kenny matter, this court has ordered Bar Counsel's office to put disciplinary proceedings of suspended attorneys on the fast track, clearly. And it didn't happen. It's 6 years now. And now I'm faced with a 12.5-year loss of my license. I guess in closing, what I'd like to say is that I know I caused my client harm, and I feel very sorry about that, and it's not what I went into the practice of law to do. I have a long history of public service, pro bono work. I've got an unblemished record. There's no aggravating factors. There's no prior discipline. And I guess I just want to say, I know that I made a mistake, but I tried to correct that mistake as best as I could, as early as I could, by putting the funds in escrow, trying to resolve the situation, cooperating with Bar Council, and moving on. The money's been paid, restitution has been made over and above. I thank Your Honors. Thank you.
Thank you, Mr. LiBassi. Ms. Weisberg?
Thank you. Good morning. Susan Weisberg for Bar Council, and may it please the Court. The major issues I would suggest presented today involve, first, whether the respondent, J. Douglas LiBassi, is entitled to any credit for restitution in the form of a reduced sanction from the disbarment recommended all the way through the disciplinary process and imposed by the single justice. And second, whether the single justice abused his discretion by denying retroactivity in this case. Before I get to those issues, I want to say just a word, if I may, about the respondent's claims about the exclusion of expert testimony in his mitigation case. We've briefed extensively, I hope adequately, let me put it that way, the reasons why there was no error in the hearing committee's exclusion of expert testimony, and addressed all the other issues raised by the respondent in his brief. But I do want to point out that by his own admission in this case, Mr. LiBassi's claimed disabilities ended in July of 2001, which was nearly a year before the probate court entered its judgment in the Morgan case. By then, he had already converted a substantial part of the Morgan money, including $15,000 due Mr. Morgan's aged and indigent parents in trust. But after his claimed recovery in January of 2001, he continued to convert the remainder of the Morgan's money to the tune of about $18,000. And all of his misconduct after his temporary suspension, including his continued practice of law and his misappropriation of about $7,500, intentional misappropriation in another case, took place long after his claimed recovery. So that even if Mr. LiBassi had put on his expert, and even if the expert had testified in accordance with the expert disclosure, none of that would have been relevant to the continued egregious misconduct, sustained misconduct that took place after Mr. LiBassi's alleged recovery. Getting to what I think are the main issues, I want to touch first on the issue of restitution. You can look hard through this entire record to find any evidence of restitution in this case, and you won't find any because there is none. Throughout this disciplinary proceeding, there was no restitution made, as I said, even to Edward Morgan's parents, who, by the respondent's own admission, never had any liability to him for any offset for fees or anything else that he's claimed. Even when the case got to the single justice and the respondent announced on the day of hearing on the information that he had made partial restitution by paying Mr. Morgan's parents, no evidence was put before the court as a matter of record. And not until November of this year was that evidence offered to this court in the form of an expanded record, long past the point of being able to reopen the record and litigate properly the effect of restitution and Mr. LiBassi's assertions. And let me also say as an aside, it would take too long to address every misstatement Mr. LiBassi made, even in his remarks here today. But it's important to remember that his statements about why this happened to him, how he got temporarily suspended, what I said to him, how I misled him or wrongfully induced him, or even that I referred him to a lawyer, none of that is a matter of record. None of it is in the findings, and none of it is true. And I hope you will keep in mind as you review this record the difference between what is in the record, what the hearing committee found, and what Mr. LiBassi simply asserts, regardless of whether or not there's any basis in the record. But in any case, I think it is important to remember that restitution was not made in this case until 2006, 4.5 years after the last 4.5 years after the funds became due and owing back to the clients in the Morgan case. And it's not because Mr. LiBassi didn't have the money. He had actually come up with substantial, although not complete, an amount of money in 2002. As he said, he put that money in escrow with his first lawyer in the case and left it there. So he didn't fail to make restitution because he couldn't. He failed to make restitution because he wouldn't. He wouldn't pay a penny back to this client or the client's parents, even though, even by his own token, he owed $15,000 plus interest of that money unconditionally to the parents.
Ms. Weisberg, could you just clarify for me the relationship, if anything, between the $53,000 and the $15,000?
Yes. The total principal amount of the conversions as found by the committee was $57,100. I don't know why Mr. LiBassi, I don't now know why Mr. LiBassi chose $53,000 to put in escrow back in 2002. That was not a sum that we suggested to him, and I don't know how he derived it. But it was not the full amount of the conversion. $15,000 of the sum converted had been earmarked to be placed in trust for the client's parents. This was a client named Edward Morgan who wanted to rescue his parents from financial crash by buying or having the family home in which his parents lived conveyed to him, whereby he would take out a mortgage, pay the parents back taxes, they were in danger of losing the house, make sure they could live in the house forever, and put $15,000 in trust for their benefit, with the remainder of the mortgage proceeds held back and earmarked to repair and rehabilitate this property. The house was in dire straits. The parents were in dire straits. The conveyance happened, but shortly after the conveyance, the parents came under the sway of Mr. Morgan's sister and wouldn't process the proceeds check. And the sister ended up suing Mr. Morgan to rescind the conveyance and get the house put in his name. And there was a restraining order entered on the proceeds, which were then being held by Mr. LiBassi. And the $15,000 is the $15,000 earmarked for the parents. That, when the probate court finally adjudicated this case in January of 2002, was ordered returned to the parents out of the mortgage proceeds with interest. And I say with interest because the probate court specifically ordered interest on the return proceeds. And one could infer that one reason is that Mr. LiBassi, and it's in the findings, had told the probate court early on that he was holding the money at interest. Not true, but that's what he had said. So that's where the $15,000 came from. When Mr. LiBassi finally paid the money back, he may tell you that it's after years of attempting to remonstrate with his client, Edward Morgan, and relentless attempts to rectify what he called was a fee dispute, not a conversion, just a fee dispute over this money. And but in fact, the record shows that there was no contact between Mr. LiBassi or his then lawyer. He's had two lawyers. At any time after 2002, when he put this $53,000 into escrow, and the hearings in January of 2004. And Mr. LiBassi's own lawyer came in at Mr. LiBassi's request and testified that they had made no contact with Mr. Morgan during that period, or even informed him that the funds had been placed in escrow. In fact, it was not until Mr. Morgan sued Mr. LiBassi in the Superior Court in 2005, after their hearings were over and while the matter was pending, that any contact was made between the two of them as of record to rectify this. Now, I say as of record. There's no evidence of this lawsuit in the record either, because although Mr. Morgan sued Mr. LiBassi in 2005, Mr. LiBassi never attempted to open the record to put in any evidence of this lawsuit. Ultimately, in 2006, Mr. LiBassi did settle the lawsuit, did pay the parents and Mr. Morgan money in settlement, but he still reserved his fee claim at the end of the day. So the picture that you may be getting of relentless efforts to resolve this matter are simply contradicted by the record. So the restitution, I would submit, first of all, was not complete because it did not include full interest. Second, wasn't timely, 4.5 years after the fact. And third, was hardly voluntary if Mr. LiBassi had to be sued to make it. And it was more than after the 11th hour because it was not until after the information was filed. I want also to talk, however, about what I think is a compelling argument on its face by this respondent, which is that when you add the term of his suspension, temporary suspension, to the disbarment, you end up with 12 years. I do want to point out, first of all, that there's no evidence of record that Mr. LiBassi wouldn't have been temporarily suspended even had he not assented. There was a well-supported contested petition before the court. But more to the point, retroactivity is not a matter of right. It is not a matter of entitlement, and it's a matter of fair exercise of discretion. And I would suggest...
And how did the judge exercise his discretion here? Does he explain that in his...
No, there's no explanation.
There's no explanation.
There's no
so
explanation.
We have no idea. The board
No.
recommended that it ought to be retroactive to the time when he came in full compliance with the temporary suspension.
The board recommended that without any finding that there was full compliance, and I will suggest that there was never full compliance, notwithstanding the board's notwithstanding the board's discussion. There was never any finding of full compliance, and there wasn't actually full compliance. But
Full
I think
compliance means he continued to practice law after August of '02?
he certainly continued to practice law and misappropriate money until May after 2000.
We understand that.
Even after that, he never rectified his false affidavit to the court, never filed an affidavit of compliance. Now, we take seriously the court's requirements for obeying its orders. It's ultimately up to this court.
So was that the reason you presented as to why it shouldn't be retroactive as it normally would be to the time of temporary suspension?
Not the main reason. The main reason clusters around the aggravated circumstances of holding this money hostage for 4 years.
Well, that's certainly all of what you say certainly justifies disbarment. I mean, I guess that's your main point. But the question is when it should be effective, where he's been suspended for the purposes of the investigation, seems like a very different question.
I agree. But if you judge this as a matter of weighing equities, I would suggest, Your Honor, that on the one side is the period of delay. And let me stress that this is not delay by Bar Counsel. There was no delay by Bar Counsel in this case. There was delay in the adjudicative process. There was no claim of delay by Bar Counsel.
I know, but all through this, he's suspended.
Absolutely.
So that's the most important point, not who caused the delay, I don't think.
We have to remember, and you're right, the time passed. But, number one, Mr. LiBassi never availed himself of the remedy he did have available to him, which was to apply to the single justice to lift the suspension based on delay or anything else. He invoked a remedy he didn't have, which was dismissal, even after Bar Counsel pointed out, after we pointed out that he could seek to have the suspension lifted. He didn't. He didn't inquire as of record at the board. And moreover, after representing to the board that he was holding this money in escrow, took the money out of escrow in 2003, put the money in a joint account with his wife, and by the time restitution came around in 2006, he had to refinance his house again to come up with money to pay the Morgans. I would suggest under these aggravated circumstances, there was reason for the judge, single justice, to exercise his discretion, and that it was not an abuse of discretion not to. We do not want to send a message, Your Honor, to the public that a lawyer can agree to a suspension, then practice, then take more money, then come up with money for restitution and withhold it, forcing the client and the client's parents to come after him, then take the money out of escrow again and spend it, wait until after the last minute, after the matter is in court to make restitution, never seek to have the suspension vacated, and then stand before the court and say, I've been a cooperative, compliant person, I'm entitled to retroactivity. This is not the message I believe we want to send to the bar. And thank you for your indulgence. I know I've gone over my time.
Thank you, Ms. Weisberg.